Students, let us continue where we left off. We were dealing with bail. We know that everybody has got a constitutional right to be released on bail in terms of Section 35. That is now the rights of arrested and detained persons. Yeah, and bail is the money that you pay as a bond for your client to be released. So sometimes it's 500 rands, it could be 100,000, it could be 50,000. Remember, we had a case of those guys who were accused of corruption at Prasa. They were given bail for 50,000 rand. Those guys, including Mr. Molife. So bail can be any amount. It can be 1,000 rand as well. It depends on how you present your case and the reasons that you give, and also the amount involved in that case. If people are accused to have stolen millions of rands, obviously the amount of bail will be a bit higher, because there's a risk involved of people going away to another country and not coming back. So you can do what is called police bail. I've discussed that police bail is also possible for a certain category of crime which is not part 2 or part 3 of Schedule 2. So if it falls under those, then there's a problem. You cannot get police bail. The only thing you can do is to go to court and do what is called a formal bail application. So we'll talk about the formal bail application, right? You will come to court and confirm your appearance for the accused by saying first of all, when you come to court, you must go and introduce yourself to the magistrate. You go and introduce yourself and you tell the magistrate that I will be in your court doing a bail application, right? Or I'll be in your court for my first appearance. You go and do that first. And when you go to the magistrate chambers, you must be robed. You cannot just go there with your robe in your hand and go there. You must go there and be presentable in your robes, and you go and introduce yourself. The magistrate might not be in her robes or his robes. You would be sitting in her office and waiting for you. So you go there and you introduce yourself and you tell the magistrate, good morning, magistrate, I will be presenting a case or doing bail in your court today. And I am Advocate Soguni, right? So you introduce yourself. You may, in most cases, you may not ask the magistrate what her name is. All you can do is to find out, because obviously you won't know where the magistrate is. Then it's either you will ask a court orderly, or you will ask the prosecutor or anybody who works in that court to accompany you, because you know it's a bit uncomfortable for just a stranger to buzz in the magistrate office. You'd rather be accompanied by someone. Even if you yourself is a magistrate, you must encourage the people that you work with that they must accompany somebody who comes to your office, because nowadays anything is possible. Magistrates are getting killed, prosecutors are getting killed. So for safety's sake, you will ask somebody to accompany you. Then that's the person you should be asking the name of the magistrate. But some magistrate can be civil. If once you introduce yourself, they will also tell you what their name is. Okay, so that's introduction. Then when the court starts, you come to court, and when the magistrate comes in, you will stand up. The court order will tell everyone to stand up, and you will stand up, and the prosecutor will then introduce the case for the day, and maybe introduce the roll to say how many cases do they have, which will be the first case, and then your client will be called to stand trial or to take a position in the dock. The dock is where somebody stands, where the accused stands is called the dock, right? And the other place is called the witness stand, where witnesses stand in order to give evidence. But the accused will stand in the dock. Okay, this is a place behind the attorneys or advocates, where advocates sit. That place behind where the accused stand is called the dock. So he will be called, and the prosecutor will prefer charges if it's if the person obviously is coming for the first time. This is which is called the first appearance, and then they will prefer charges, and the accused will be asked if he pleads guilty or not. Normally they plead not guilty, and then you will stand up as the accused, because you would have been introduced to say Mr. So-and-so is accused of a certain crime, in that on a certain day he committed a crime of maybe perjury or theft or assault, and then the prosecutor will say the accused is represented by attorney so-and-so, meaning your name, and then charges will be preferred, and the accused will deny or admit to the charges, and you will stand up and confirm your appearance, say morning, although you had already greeted in the magistrate in the chambers. Again, for the purpose of the record in court, you will stand up and say, "Good morning, Your Worship. I confirm my appearance for the accused. My name is Advocate Sobon." Although you have said, you've already told the magistrate in chambers, but you still have to repeat that for the record. And then you will also say, and the plea of not guilty is in accordance with my instructions. And you can also say that the accused will also ask for the leave to do a bail application. Then if it's allowed, if the prosecutor is agreed, then you can go on with your bail application. But it may, in some cases, the prosecutor will say the accused address, because you must know the accused is still in custody, right? He is still in custody, and investigations are still outstanding, and there could be a possibility that also the address has not been verified, or else which address are we talking about? Sometimes somebody will just hear maybe called to say you've got a case to answer, and then he hands himself over to the police. Police will detain him. They don't know where he comes from, so then there's a duty for them to verify the address, including the alternative address. So police have a duty to go and verify those, so that if somebody doesn't come to court, then they'll be able to go and look for him, find him, and bring him to court. So if addresses have not been verified, the prosecutor might ask that the matter be postponed for 7 days, for them to be given time to go and verify the address of the accused. Okay, and the next step will be, let us say now the prosecutor agrees that bail should be, bail application can be done. The next step will be for you to take, I would prefer that you take a prepared affidavit and read it to the record. That's the affidavit that will state the name of the accused, the age of the accused, the qualifications and the employment address, and state whether the accused has pending cases, has got previous convictions, and whether the accused is pleading guilty or not guilty. Obviously, pleading not guilty, because if you plead guilty, immediately the court will sentence you. So, for the purpose of bail, you will plead not guilty, and also, this is very important, you need not address the merits of the case. If you do address the merits of the case, you must know that you will not get bail, especially when nobody has said anything about the accused. All you can say is, at this stage, the accused does not wish to deal with the merits of the case, but all the accused is saying that he is now pleading not guilty. And you also state that the accused will not interfere with investigation or interfere with witnesses. And obviously, at this point in time, he may not know who the witnesses are, because the case is still under investigation. And you state that, and then you request that the bail be granted, and also state that he is amenable to any conditions that the court may impose, and is prepared to hand over his passport to the IO if he's got a passport. In most cases, your clients won't have a passport, but if he's got a passport, you need to disclose that, and also be amenable to handing it over to the IO. And if the accused has work that he does outside of the country, you need to state that, and also state maybe that if he wants to travel, he will get he will seek permission from the IO. And then at the end, you will say that is the applicant's case, because at this stage, the accused is now an applicant and the state is the respondent, because we are doing a bail application. So you will be addressing the accused as the applicant, and even in your statement, you will say, Mr. So-and-so applicant, and the state will be respondent, because this is an application for bail. Okay, and then the prosecutor might stand up and say he does not oppose bail, and bail will be granted. And when the bail is granted, the court will definitely warn the accused in terms of that he should not interfere with investigation, and that he must make sure that on a given date he comes to court in order to answer to the charges or to stand trial. And if he does not, bail will be forfeited to the state. So that is how you do bail. We will also go on and do bail for minor offenders. Here we are dealing with adult offenders. We will do bail for minor offenders in accordance with the Child Justice Act. So let us stop there for now. If there are any questions, you subscribe and you ask the question, then we'll deal with your questions online, or you ask the question in class.